I often get clients who think that giving assets to children before they pass away is the best way to create an estate plan. Today, I'm going to talk about why that's not the case and how you lose out on huge tax benefits if you do this. So let's get into it. All right, there are a few different reasons that people want to just gift assets to children before they pass away. Often people don't want to do any type of estate planning. They don't want to do a will. They don't want to do a trust. And so their way for circumventing this entire estate planning process is to go ahead and gift assets to their children. And there's two things that really pop out. I said first that I was going to talk about the tax aspect. Before we do that, let's actually just talk about kind of a more practical legal aspect, and that is this idea of asset protection. So the reality is, if you go ahead and you give maybe assets to your children, but you're still depending on those children to be able to spend those assets on you, the parent. Maybe you need long-term care, maybe you need to pay your mortgage, maybe there's a lot of different other things, right? Maybe you need to pay your car payment or your homeowner's insurance or your life insurance. It goes on and on, your groceries, etc. The thing is, if you give those assets to your child, then those assets are going to be susceptible to any type of personal creditor claim of the child. So think about a divorce or some type of malpractice suit or a negligence suit. The point is, if, I don't know, someone falls on their property and busts their head open, they could potentially have a lawsuit, a personal creditor claim against your child, and therefore any assets that you just gifted over because you wanted to circumvent an estate plan with a will or with a trust or with both, now all of a sudden you run the risk of losing those assets because you didn't want to spend the money on an estate plan. All right, so that's one aspect, and that's how often does that happen? Not to most people, but the reality is it definitely does happen, and we see it. We see it when a child gets divorced. We see it when maybe they weren't paying attention and they pick up their phone and to look at a text and they run a red light and they smash into someone and they end up killing someone in a car wreck or something like that. Or maybe it could be something more nefarious. But the reality is this is not a true estate plan, right? So anyone who goes to the trouble to creating an estate plan is going to circumvent this whole opening themselves up to the legal risk of one of their children. All right, so the other aspect of this is getting a step up in basis. So tax basis is really important, all right? So when the IRS determines whether or not that there is a capital gain that's going to have to be paid, they determine it on whatever the basis is. So they'll look at what the fair market value of the asset that was sold. So let's just say you have a security that you sell for $10. If you bought it for $1, then there's going to be a $9 capital gain that you're responsible for. All right, now if you gift the asset to the child during your lifetime, your child takes that $1 basis. So they end up selling it for $10, then they themselves are going to pay a $9 capital gain. However, what the government does do, and they do us a favor in this regard, if you want to call it that, is that when a person receives an inheritance from someone else, such as a parent, then they get what's called a step up in tax basis. So rather than taking your $1 tax basis as they would when you gift it to them, they get the fair market value of the asset, usually upon the date of your death, as their tax basis. So let's just say you die, it's worth $10, you give it to them through your estate plan, they're going to take that security at a $10 tax basis, and then they are also able to sell it if the fair market value is $10. Just say it's $11 at that when they decide to sell it. Then they're only going to have to pay a capital gains tax of $1 if it's $11 or 0 if it's $10. So the point is that if you wait to pass assets upon your actual death, then your children are going to get a step up in tax basis. And this is huge, particularly when it comes to securities or a personal residence of mom and dad. Often that's the asset that people want to make sure gets passed to the children before mom and dad pass away, so they'll just gift it to them. There's usually a huge tax consequence that comes with that. So don't gift the personal residence, don't gift assets in general, unless it really makes sense. Make sure it's a balancing act that you need to consider whether or not you want to get that step up in basis. And I think most people should be planning for that. So make sure you're not gifting assets for purposes of, minimizing legal risk, legal exposure to yourself, and also minimizing any capital gains tax.